Welcome back, everyone. In today's lecture, we're continuing our exploration of drug policy, not just in terms of laws, but in how those laws are actually enforced on the ground. Today, we're going to focus on three key areas. First, we'll talk about how discretionary policing shapes drug enforcement outcomes. Then, we're going to talk about a case study of stop and frisk that is used as a tool for proactive drug policing. And finally, we're going to talk about the impact of sentencing differences, particularly in how crack and powder cocaine have been treated under federal law. Throughout the discussion today, we're going to be talking about one big question. How does the way that we enforce drug laws shape public trust, perceptions of fairness, and real-world outcomes? Let's go ahead and begin. Policing is not mechanical. It's judgment-based, and that judgment involves discretion. Every day, officers and departments make decisions about where to deploy resources, which neighborhoods to patrol, and what kinds of behaviors to prioritize. That discretion is not inherently problematic. It's a necessary part of policing, but how it's applied can produce patterns that favor some groups or areas over others. Drug enforcement offers a clear example. Public consumption, meaning use on street corners and parks, is more visible than private use. So even if rates of drug use are comparable across communities, enforcement tends to concentrate in public spaces, which are more common in low-income, high-density areas. Discretion also shows up in decisions about who gets searched, who gets cited, and who gets arrested. These decisions accumulate and create enforcement patterns that don't always reflect actual behavior, but instead are reflective of where and how police are looking. This is important. Two people engaging in the exact same behavior may face very different consequences depending on context and officer perception. Let's take a closer look at stop and frisk, a controversial strategy that was used most notably in New York City during the 2000s and early 2010s. This policing approach allowed officers to briefly detain and search individuals based on reasonable suspicion that they might be involved in criminal activity or carrying contraband. The idea was proactive policing, identify potential threats before the crimes occurred. So how did this play out? About as well as you would expect. Roughly 90% of those who were stopped were Black or Latino men. And in the overwhelming majority of cases, no drugs, no weapons, or evidence of a crime were ever found. Most stops ended in nothing more than a brief encounter. Though, for those who were stopped, the experience was anything but forgettable. The policy sparked intense public debate over effectiveness, fairness, and police overreach. To fully understand how it became legally possible in the first place, we need to go back to 1968. The legal foundation for stop and frisk practices come from a landmark Supreme Court case, Terry v. Ohio, 1968. In that case, the Supreme Court ruled that police officers may stop and briefly detain a person if they have reasonable suspicion, which is a lower standard than probable cause, that the person may be involved in criminal activity. If the officer has reason to believe that the person may be armed, they are permitted to perform a limited search of outer clothing for weapon. This ruling established what we now call Terry stops, and it created a powerful legal tool for law enforcement. But it also created gray areas because reasonable suspicion is a very subjective standard and one that can be interpreted broadly. In New York City, that broad interpretation came fully under scrutiny in the 2013 federal case, Floyd v. City of New York. The court found that the New York Police Department's implementation of stop and frisk policies violated both the Fourth Amendment on unreasonable searches, and the 14th Amendment on equal protection. The judge did not say stop and frisk itself was unconstitutional, but the way in which it was being carried out was. The ruling led to major reforms in New York policing and pushed departments across the country to re-examine how they use discretionary stops. So while Terry v. Ohio gave police a powerful tool, cases like Floyd remind us that how the tool is used and whether it is applied fairly matters just as much. So now let's turn from street level enforcement to sentencing. Specifically, how certain drug laws have produced drastically different penalties for similar substances. A primary example focuses on the federal sentencing disparity between crack and powder cocaine. Enacted in 1986, the law imposed a 100-to-1 sentencing ratio, meaning that someone caught with just 5 grams of crack cocaine would face the same mandatory minimum sentence as someone with over 500 grams of powder cocaine. This policy was part of the Anti-Drug Abuse Act, passed during a time of widespread concern over drug-related violence. But over time, questions began to emerge. Was this disparity evidence-based? Was it achieving its intended public safety goals? And what kind of communities were feeling the broader impacts? We'll explore those questions and trace the road to reform in the next section of lecture. So let's go a little deeper into how this sentencing disparity changed and what hasn't changed. The 100-to-1 sentencing ratio between crack and powder cocaine was one of the most criticized features of the federal drug law. Enacted in 1986, it reflected a period of intense concern about drug-related violence and media-driven panic over so-called crack epidemics. But it wasn't grounded in scientific evidence. Research showed that crack and powder cocaine were chemically similar, carried comparable risks, and were used by different populations, primarily based on cost and form. Still, the 100-to-1 rule remained in place for over 2 decades. By the early 2000s, bipartisan concern was growing. Think tanks, legal scholars, and both conservative and liberal lawmakers alike began to question the logic and fairness of the policy. The U.S. Sentencing Commission recommended changes as early as 1995, but Congress didn't act. It wasn't until 2010, under the Obama administration, that meaningful reform was finally passed. The Fair Sentencing Act reduced the disparity from 100-to-1 to 18-to-1. It eliminated the 5-year mandatory minimum for simple possession of crack cocaine. It also applied new weight thresholds for sentencing as well. This, in essence, was a major policy shift. It didn't eliminate the disparity altogether, but it was a clear acknowledgement that the original policy had been overly punitive and ineffective. Still, the act was not retroactive when passed, meaning that thousands of individuals who were sentenced under the old rules still remained incarcerated. Later legislation, like the First Step Act of 2018, began to correct this by allowing retroactive sentencing reductions in some cases. So while the 2010 Fair Sentencing Act represents an important example of evidence-based reform, it also reminds us that once punitive drug policies are enacted, it can take decades to unwind their effects. Whether we're looking at stop and frisk or drug sentencing, one thing becomes clear. Enforcement patterns don't just impact individuals, but rather they shape entire communities' relationships with the justice system. Let's consider 2 contrasting communities. In one, police presence is routine. Stops are frequent and minor infractions often result in legal consequences. In the other, drug use may occur just as often, but with fewer patrols, less visibility, and more social capital to avoid arrest or prosecution. The first community is likely to feel policed, not protected. The second may never fully recognize how enforcement strategies differ. These differences erode trust, complicate cooperation between residents and law enforcement, and deepen perceptions that the system isn't applied evenly. And again, this happens even when the laws themselves are written to be applied to everyone equally. So what have we learned today? That policing involves discretion, and how that discretion is used has a major impact on who gets stopped, who gets searched, and ultimately who gets arrested. Policies like stop and frisk, while facially neutral, can often play out unevenly in practice. That sentencing laws like the crack and powder cocaine disparity have contributed to vastly different outcomes for similar offenses, often based on where and how enforcement is happening. As we move forward in this course, we'll continue to explore how the structural differences of our justice system occur, both in formal laws and informal practices, and how they shape the outcomes on the ground. For the next time, we're going to take a look at the role of the prosecutors and the courts. Who gets charged, who gets diverted, and what happens after arrest. Thank you for your time, and I'll see you next time.